Hi, I'm Elisa Lamel, Legal Content Specialist at Kraus Financial Services. On this episode of Elder Law Interviews, I'm joined by elder law attorney Shirley Berger Whitenack. A partner at Shank Price Smith & King LLP in New Jersey, Shirley dedicates a substantial portion of her practice to trust and estate litigation and elder and special needs law. She is a past president of NAELA, as well as a NAELA Fellow and a member of NAELA's Council of Advanced Practitioners. Shirley also serves as a mediator in probate and guardianship matters, and today she'll be sharing her insight on when mediation is an appropriate choice for families, how the process works, and some of the benefits of choosing mediation over litigation. Hi, Shirley. How are you?
Good. How are you?
Oh, very good. Very good. Well, thank you so much for being with us today. So today we're going to be talking about mediation, some of the benefits of mediation, why clients might choose mediation. So the first question we'll start with, what is mediation? How do you describe it to your clients?
So, mediation is an informal process whereby a neutral individual is chosen to facilitate negotiations between or among the parties in a private setting to assist them in coming to a resolution regarding whatever the dispute or disputes are, and to hopefully settle the matter to avoid having to go to court or having a trial.
Okay. So who are the type of clients or the client scenario that's a good fit for mediation? And are there ever situations where mediation is not appropriate?
Sure. So mediation is a lot of times the issues are, for example, the elderly person has cognitive decline, and the issue is they need a surrogate decision maker. They didn't sign a POA or an advance directive, so they may need a guardian, and everybody agrees that there needs to be a guardian, but the dispute is who should be that guardian. Or there may be an issue as to whether mom should stay at home, whether she should go to an assisted living facility or a nursing home, for example. Or there may be an issue of allegations of lack of transparency for the person who is an agent under the power of attorney, for example, allegations of financial exploitation or other forms of abuse. So all of those may be good reasons to think about going into the mediation process.
Okay. Okay. And are there ever situations where mediation is not appropriate?
Yes, so I would not recommend mediation where there are allegations of substance abuse, physical abuse, emotional abuse. You have participants who are hot-headed, ill-tempered, that sort of thing, or if there's an emergency that needs to be resolved. Those are not good situations for mediation.
Okay. And you touched on a couple reasons that a family might end up in mediation. What are some of the disputes that you're hearing in these mediation sessions? Are they just arguing over who should do what, who should be dispersed what, or how do those look?
So it really runs the gamut. Sometimes the dispute is, for example, there may be family members who think that mom should stay home. They will care for mom, or they will hire a home health aide. Other family members may feel that by doing that, mom isn't going to get the social interaction from other people her own age, because all she does is sit on the couch and watch TV all day. There may be concerns that with various viruses going on, whether it's, COVID or C. diff or MRSA or something, that the elderly person may be more susceptible to becoming ill in a nursing home or an assisted living facility where there may be other sick people. So that is common. Another common dispute is one of the children, for example, has power of attorney and is not providing information to the other siblings about mom's finances, how they're being used, or even medical information. So those are the types of common disputes that I have found that often are raised in the mediation setting.
Okay. So can you walk us through a little bit what a mediation session is actually like? I mean, who's involved in the meeting? How long is it? Those kind of things?
So typically when you have a mediation, and this is also going to run the gamut, there's going to be a determination as to who that neutral person is. It could be an attorney. It doesn't have to necessarily be an attorney. It could be a therapist, or someone else who maybe has taken mediation training, or it could be an attorney. If the parties do have lawyers, those attorneys may come with their clients to the mediation. These days, the mediation may be in person or by Zoom. And typically, in either case, whether it's in person or Zoom, there will be breakout rooms, so that what really happens is that the mediator shuttles back and forth among the various parties, speaking to them typically privately to find out what their real concerns and issues are. The participants may want to, for example, tell the mediator certain things in confidence that they don't want the mediator to necessarily disclose to the other side. But basically, a good mediator has to really listen to what the parties are saying and then see whether they can think outside the box and come up with solutions that will be palatable to all of the participants in the mediation. So the concept is to find out what are the common points that everybody agrees with. For example, everyone agrees that mom has cognitive issues now and needs assistance. So if everybody agrees with that, that's a good starting point to figure out, how do we move forward here? Is there already a power of attorney in place? And if so, can we just, have an agreement whereby, for example, the agent will tell the other participants, information either about mom's medical issues or money, or both. And then what the mediator will try to do is to get the parties closer together by trying to take one of these issues in dispute and come up with ways to resolve the issue. So, for example, it could be that one of the children is the healthcare proxy, but there can be an agreement whereby the other children have access to the medical providers or to medical information directly and doesn't have to go through that agent. The agent can just give permission for that to happen. Or it could be an agreement whereby they decide that they're going to hire a care manager who is going to be reporting to all of the family members that are interested in this mediation. So it really depends on what the dispute is, but a mediation will be, I believe, much more tailored to resolve some of these issues than running into court, where the court may not have as much flexibility as the parties to resolve some of these issues.
Absolutely. So, can you talk about how a resolution is actually reached? So you talked about how you're looking for those common points between both parties, things that they already agree upon. So what might a mediator recommend as some resolutions?
So, for example, there may be a resolution whereby, let's say there's two siblings that are arguing over who's going to care for mom. There may be an agreement that one of them will handle the money and the other person will make the medical decisions. Or there may be a determination that both of them will handle medical, but one of them will handle the money. So those are common issues. There may be issues that they have, how will I make sure if I'm not the person who's making the medical decisions that I'm going to have access to know whether mom is in the hospital or whether her condition's taken a turn for the worst or what have you. It may be visitation issues coming up. So it's really a question of listening to what that issue is and seeing whether you can get the other side to agree. Essentially, what you're doing is you're going to ultimately want to have a written contract, if you will, that will have these provisions in there, and everybody who signs this will be bound to follow the terms of the contract. You may want to, for example, have a mediation settlement agreement that provides for a tiebreaker in the event that there is a dispute as to medical treatment or financial. It may be the appointment of a geriatric care manager. It may be another attorney that would play that role. So it really depends in large part on what the actual issues are that are in dispute.
Okay, so what about when a family decides that they do need mediation services, they do want to work with a mediator to get a dispute settled? How do you find a mediator in your area? Is it something you can just look up? And then what are they looking for in a good mediator?
So I think that the best way to find a mediator is to do it by word of mouth, just as you would want to hire a lawyer typically is going to be through word of mouth. So you want to find out, for example, if there's a listserv in your community, you may want to ask, have you done any mediation? Who did you use? Were you satisfied with their services? Another way to do it is to contact your local county or city or state bar association and see whether there are mediators. In New Jersey, where I practice, we have a roster of approved mediators. They are approved by the court. They have fulfilled certain requirements of continuing legal education to become a trained mediator. And they're in New Jersey, we actually have a website where the information will tell you who the mediator is, what they charge, what practice areas, excuse me, they're willing to do. So there's various ways to do it. And in some cases, the court will appoint a mediator that, people will either have to use or may have the ability to say, no, I'd rather use someone else. In this sphere, we not only focus on issues of guardianship or where the elderly may live, but it may be accounting issues. It may be estate administration issues. It goes broader than just simply taking care of an elderly person. So it's really a question of, what are the issues here and who, as a mediator, is best to handle those kinds of issues.
Okay, so a mediator isn't all encompassing. They don't handle all sort of disputes. You can specialize in certain practice areas that you settle disputes in.
Correct, absolutely.
Okay.
I would not feel comfortable as a mediator, for example, mediating an employment law dispute. I don't know enough about that law in order to do that. Now, one of the important things about a mediator, they don't make a decision. They're not judges. They're not arbitrators. They're just basically trying to facilitate a resolution. So what do people look at for a good mediator? A good mediator is someone who has a track record, frankly, of being able to settle cases. A good mediator has the temperament to really listen to people and not judge people. Because if you're going to judge who's right or wrong, people are going to get very defensive in the mediation. It's going to be very, very difficult to settle it. So it's got to be somebody who is really listening to what the parties are saying, and the participants have to get the sense that they're being listened to.
That's so important, I think, to be a really good listener and advocate for both sides, really.
Right. And you have to also, as a mediator, have patience because it can take a while to get people closer together.
So, how do you define a successful mediation session? When you walk out of there with a resolution, when both parties are mad at the resolution, how do you define successful?
Well, so typically mediation is going to involve compromise, right? So there's going to be a give and take. And some people may not be happy that they have to give something up. Um, and it's been said that a good mediation is when all of the parties walk out a little unhappy because that means that they've given up something. When people are in order to settle a mediation, people have to be voluntarily coming to the table and working in good faith to come up with solutions to the problem. It's not just the mediator who's doing all the hard work. The participants have to do that too by determining what it is that they are willing to compromise on. And so a part of a successful mediation is to resolve those disputes through compromise. And if you can reach a settlement, especially a written settlement, again, a contract that is going to be binding on the parties, then you really have successfully concluded the mediation.
Okay, so let's touch on the resolution part a little bit. So you just mentioned that when at the end you should have a written contract and then that's binding. So is there any way that the next party the next day could have sort of that buyer's remorse, not want to uphold their end of the agreement? What happens if that happens?
So when you are doing a mediation, if you don't sign an agreement of some sort, that very well could happen. The next morning, everything can just blow up and people can say, you know what, I've been thinking about it and I don't want it. What happens to that will depend in what jurisdiction you are in. So some states may say, look, you've come to a verbal agreement and I'm going to enforce that. In some cases, the court may say, no, it's got to be in writing. In some cases, you may have resolved certain issues, but it may be so ambiguous that the court wouldn't even know how to enforce the agreement. So it really depends. In New Jersey, if a mediation is court ordered, which we sometimes have, we have case law that says that the only way a court can enforce the resolution of that mediation is if there is either a writing or a recording of that agreement so that the court knows what to enforce. So you don't get stuck in a he said, she said situation, but there may be other states where a verbal okay is sufficient for the enforcement of that mediation agreement. Sometimes what's also going to happen is there may be other terms that people didn't think about during the mediation that need to be further addressed. So sometimes you can't necessarily end the mediation in one day. It may have to go on for another day because you may need more information about taxes, for example, or other information that you may need in order to bring the case to a resolution.
Okay, and I would imagine it would be more cost efficient to handle these disputes in mediation versus going to litigation. Is that true?
Well, yes, typically, because during a mediation, you're not going to have witnesses testify. You're not going to have rules of evidence. You're not going to have a court restricted by what they can decide or what they can't decide. It's the parties coming together with a settlement. And more importantly, if you go to court, whatever the judge or the jury decides may be subject to an appeal. So you're not over the case, even though an opinion has been rendered by the court. If you have a successful mediation, however, you are generally done. The next step is to follow the terms of the mediation. There's no appeal, and so the costs will be significantly less. Also, one of the questions that comes up, especially in post-COVID times that we now have, is there a backlog in the court system? How soon can the court even have a hearing or a trial on this issue? So you may be able to resolve it a lot quicker through the mediation process than by waiting for a court to make a determination that it has the time to have a hearing, or you're dealing with a jury, depending on, again, where you are.
Lots to think about. I think those raise some really good points on why mediation might be more beneficial in certain situations. All right, Shirley. Well, thank you so much for your time today. It's very much appreciated. For any of our viewers who are watching who may have questions about getting started in mediation, what the process is, how can they connect with you and ask you those questions?
I'd be happy to talk to anybody who wants to talk about mediation. You can either email me at sbw@spsk.com or give me a call at 973-540-7336. I'm happy to help people who are interested in mediation.
Thank you so much, Shirley.
Thank you.